how does an insurance company defend your allegations, your claim that you're injured, that you're in pain, that you need ongoing health care, that you are losing income maybe, and it's all because of this accident? Sometimes there's a misunderstanding where the client believes that the insurance company is paying them because they've been through some traumatic event that resulted in injuries, and therefore they should be entitled to pain and suffering, money for income loss and healthcare expenses, and things of that nature, maybe assistance around their home. I have had clients say, it's really obvious that I'm hurt. I'm the victim. I was doing nothing wrong. It's clearly their fault. They rear-ended me, or worse, I was a pedestrian and I got hit. And I was in the right. I was in the crosswalk. I was doing everything appropriately. And you're correct. You are correct insofar as it wasn't your fault and you were hurt and you are hurt. But it's not enough to the insurance company. They intentionally delay and deny claims with the expectation that your case will get weaker and weaker, and it will be harder for you to tell your story successfully in front of a judge or a jury by the time you get to court. They're hoping by that time it's a distant memory. You're much better now. You're not seeing doctors. It's not having a major impact on your life, at least in a visible way to a jury. And so it's incumbent upon you as the injured party, as long as your case is ongoing, but more importantly, as long as you're having symptoms, to continue to treat those symptoms, continue to try to get better. There's another important reason to follow the advice of your treatment team and create risk for the insurance company so that they're going to pay you more for your case without going to trial against you. Okay, now, how does an insurance company defend your allegations, your claim that you're injured? How do they defeat that? Well, a couple of ways. One, they ask questions, take depositions, they poke holes, they test the witnesses to see how strong the case is. But the other way is in the affirmative. The insurance comes out with its own theory. So they present a different set of facts, an alternative theory to the jury or the judge. Let's send you to our doctor. Let's see what our doctor has to say about your injuries, if they're as significant as you say. The insurance companies have extremely deep pockets and resources, so they can typically locate very well-credentialed, well-spoken physicians to assess you. And these physicians, more often than not, no matter what your injuries are, will downplay the severity of those injuries because they're doing work regularly on behalf of insurance companies, and they're being paid handsomely to give opinions to support insurance companies, to reduce the risk to the insurance companies so that they can pay you less for your case. There's no mystery. They're paying thousands upon thousands of dollars to another doctor for only one reason, so that they can overall save money on claims. Let's look at that for a minute. So they get a doctor who says you're not as hurt as you say you are, and they expect to present that to a judge or a jury. On your end, what do you have? Well, if you haven't treated much in the last year, you maybe have an expert that your lawyer's hired, just like the insurance company. And so now the jury is faced with two alternative theories, both by doctors that really don't know you, that have seen lots of people simply in the context of litigation. And just as much as your lawyer wants to argue, well, that doctor's really not as reliable because he was hired by the insurance company, well, the alternative is going to be argued by the defense. Why should you believe the plaintiff's doctor? Their lawyer hired that doctor to give an opinion here in court. The real differentiation comes from the treatment team. They have nothing to do with the case. These are healthcare people that are involved with you for one reason, to try to get you better. Most of the time, they've seen you on multiple occasions over an extended period of time. They recognize you when they see you. They know your name. You're not just a file to them. You're a patient. That's another distinguishing factor that helps you overcome the insurance company's alternative story or alternative theory about your case. Another way I often explain this, litigation is like having a ticket to ride a train. So your ticket allows you to board the train, and the train is the civil justice system. It's what allows private individuals to bring or advance a claim if they sustained a harm or loss because of somebody else's negligence. And now this train is headed to a final destination, which is the courthouse, more specifically the trial. Okay, that's where it ends. That's the very last stop. But along the way, it stops for discovery, documents that are exchanged. It stops for depositions, which are oral examinations where the lawyers get to ask questions of the other party. It might stop for a mediation or other settlement conference. There's motions, which are arguments in court between the parties. There are all these different stops before you get to trial. And along the way, the insurance company will be walking up and down the train, and they'll come to you and they'll say, why don't you get off at this stop? Then we're going to buy your ticket. Can't get back on the train. You're not going to go to the final stop. And they'll offer you some money. And with the advice of your lawyer, you'll decide at that point if it's enough. And if it is, you'll get off the litigation train and you'll never see that final stop of trial. But very often you'll say no, because your lawyer will tell you, no, we have momentum. We have support. There are supporting doctors and treatment providers and family members and coworkers and friends and all these people that will get on the train with us. We're going to pick them up at this stop. You get some updated clinical notes and records. And so that doctor's now boarded the train with you and is seated next to you. And invariably, the insurance company who's also riding the train sees that. And so they come around again. And this time, instead of offering you $500 for your ticket, they say, we'll give you $750 for your ticket if you get off the train now. They're paying you to get you off the train. And they'll pay you more, typically, the closer you get to the last stop, provided, this is the big key, your case appears to be getting stronger and the risk increases to the insurance company. And so by that, healthcare, family members, friends, all these people board the train with you and will come with you to trial and be there for you to help tell your story. So the reason I'm sharing this is because it comes up very often with clients that are trying to understand, why isn't the insurance company offering me more money? I am hurt, and I've been hurt ever since. And I told them I was hurt at my deposition. And I'll tell them again how hurt I am. And I told them about the challenges I have every day, and the pain I go to bed with, and the pain I wake up with, and the difficulty sleeping. And all that's true and fair. But the insurance company looks at that case and says, well, that's going to be a more difficult case to prove in front of a jury than the person that has the robust treatment team that dovetails with that story and really helps to explain that story. Ask questions to your lawyer, get advice, find out what you could do to help maximize the value of your case. If you have any questions, we're always here for you. You can call us or you can complete our contact form, and we're happy to answer your questions. I hope you found this video informative.